Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we delve into the latest news on privacy, data protection and cybersecurity from all over the world. And we do this most of the cases with our experts coming from the different countries where the news are coming from. In this case, I'm pleased to be here together with Zelda Daisy and Sean O'Donnell from the law firm Byrne Wallace Shield, based in Ireland and exclusive member of the Privacy Rules Alliance, to discuss about a very relevant topic and very recent topic, which is the recent fine issued to TikTok by the Irish Data Protection Commission. It's a big and relevant fine, 530 million, if I'm not mistaken. So definitely something we are interested to dig a bit more into. But first of all, Zelda, Sean, thanks a lot for being with us today. It's a pleasure to have you.
Great to be here, Sandro.
Okay, so I would like to immediately start with, having an understanding of what we are talking about. So I would make my first question to you, Zelda, in relation to, the key findings that were behind this decision of the Data Protection Commission to fine TikTok. Can you just give us an overview on what was that about?
Sure, thanks, Alessandro. Well, as you'll be aware, the Irish Data Protection Commissioner, or DPC, is the lead supervisory authority for TikTok, as well as a significant number of other global tech giants. And on the 2nd of May, it imposed a significant administrative fine on TikTok for breaches of the GDPR in respect of personal data transfers to China. And in fact, this is the third largest fine levied under the GDPR to date. The inquiry itself focused mostly on the lawfulness of the transfers and also whether TikTok had met its transparency requirements in transferring the data. And the DPC, in looking at those two areas, it found first on the lawfulness point that TikTok transfers to China had infringed Article 46(1) of the GDPR. And it said that TikTok had failed to verify, guarantee and demonstrate that they had sufficient supplementary measures in place, and that the standard contractual clauses, which was a mechanism used in this case to validate the transfers, were effective to protect the data against access by the Chinese government. Then secondly, on the transparency requirements, the DPC found that TikTok's privacy policy was inadequate. And it focused on two key respects when it looked at the policy. It first of all said that it had not named the third countries, including China, to which the data was being transferred. And secondly, it didn't explain the nature of the processing operations involved. So in this case, the processing had included remote access to personal data, which was stored in Singapore and the US by personnel based in China. And a lot of people mistakenly don't think that remote access is a transfer. And in fact, it is classified as a transfer under the GDPR. So what was very interesting about the decision is TikTok did have an appropriate mechanism in place here. They had standard contractual clauses in place to protect the data, but the standard contractual clauses are insufficient in themselves. And it's also necessary to carry out a transfer risk assessment. And the DPC here held that even though the standard contractual clauses were in place, the DPC or TikTok hadn't demonstrated that it had sufficient supplementary measures in place to protect the data. So as you know, there are various measures that you can put in place. They can be technical, organizational or contractual measures. And the DPC made it very clear here that the standard is to ensure the same high level of protection provided to personal data within the EU, where it goes outward to a third country.
Thanks a lot, Zelda, for this introductory overview on the key findings, which is extremely interesting. Another question to you is, how would this impact all the businesses that are in a kind of similar position, meaning having, transferring data outside the EEA, for example? Do you believe that this has a strong impact, not that strong? How do you see it?
Yeah, well, look, this is an important thing to consider, because I think when a lot of people look at the fine, they think it just relates to big tech. But I think it's important to note that the fines and the requirements are not just limited to very large companies. And the DPC and other regulators' expectation is that smaller businesses will endeavour to comply with these requirements as well. The other very important factor is that the decision doesn't in fact prohibit transfers of personal data to China once you meet the relevant criteria. And I appreciate that these can be quite onerous for businesses to meet, but we do work with clients, almost on a daily basis to assist them with their transfers and to try to ensure that they can be done in a compliant manner where possible. The main circumstance, I suppose, where we would see this for our clients would be where they engage contractors outside the EEA to provide IT or other remote services, or where they have, for example, intergroup transfers within a client group, or it could be where there's a proposed transaction. So, for example, with an acquirer or investor that's based outside the EEA and they're carrying out a due diligence process, on an Irish company or company based in the EU. So our advice to all controllers transferring personal data outside the EEA in the context of this decision would be to take stock and review and assess their non-EEA transfers, and to try to ensure that they have the appropriate measures in place to comply with their legal obligations. So just to be clear as to what those are, you need to have either an adequacy decision in place. So if the EU has deemed a third country adequate, and there's an EU Commission adequacy decision in place, then the data can be freely transferred. Otherwise, you need appropriate safeguards. And as we're discussing, the most common is the standard contractual clauses. In addition, where you use the standard contractual clauses, you have to be very careful as an exporter to also carry out what's known as a transfer impact assessment or transfer risk assessment. And I think that that's where a lot of companies can fall down. They don't realise that that requirement is there and that they must have this assessment, and it should be in line with the European Data Protection Board or EDPB guidance in the area. And then as a result of that assessment, it can reveal that there are gaps or that there are issues. So, for example, in this case, the Chinese government being able to access the data, and then looking at what supplementary measures can be taken to actually protect that transferring personal data. The other aspect, as I mentioned, would also be looking at having a very clear and easily understandable privacy policy, and which sets out the organization's position on non-EEA transfers. So in simple terms, you have to tell people where their data is being sent. So they will be my main suggestions, in the context of the decision.
Which is extremely useful. So thanks a lot for this, Zelda. I think it was a very practical answer, and it sounds like you have a bit of experience on this, meaning that it sounds like it's not something completely new. With make me wondering about other cases that were similar to this one that allowed you to be able to understand what's going to happen next, or based on what happened in the past. And maybe this is my question to you, Sean. Have there been any similar case in the past to look at?
Yeah. Thanks, Alessandro. I suppose there have. This is the TikTok case, I suppose, is one of a series of cases which show that the European supervisory authorities are becoming focused and take this transfers and preventing not having adequate safeguards in place for transfers outside of the EEA, that they're taking it very seriously. Zelda mentioned the Meta case, and I think probably everyone is familiar with that. It goes back to 2023, and the fine was 1.2 billion euros, which is very significant and remains very significant. But I'm going to focus as well, because it's not just in the Irish DPC that has imposed these fines. I'm going to have a look at one case, the Uber case, which was a fine imposed by the Dutch Data Supervisory Authority in last year, so it's recent enough, it's August last year. They imposed a fine of 290 million on Uber, and that was similar insofar as it was failure to have appropriate safeguards for intra-group transfers to the US, between Europe and the US, as is required under Article 46 of the GDPR. So in this case, the Dutch Supervisory Authority found that Uber had transferred personal data from the EU entity, Uber BV, to the US entity, Uber Technologies Incorporation, under a joint controller agreement, and that this was in violation of GDPR because the safeguards that are required weren't in place. And in this case, there was no standard contractual clauses in place. And in this case, just for an example, that the type of information, the type of data that was transferred was account details, taxi licenses, location data, payment details, identity documents, criminal and medical data. So there was also special category data included here. And this complaint came from France, actually, came from a number of taxi drivers in France who made a complaint to a human rights interest group, who subsequently complained to the French Supervisory Authority, the CNIL, and it ended up being dealt with by the Dutch Supervisory Authority because Uber has its main establishment in the Netherlands. And interestingly, Uber put forward a number of arguments to defend the practices, but its key argument was that the standard contractual clauses weren't necessary because Uber Technologies Incorporation was already subject to Article 3.2 of the GDPR as a joint controller. So Article 3.2 is the extraterritorial provision And because of that, they said Chapter 5 in Article 46 didn't apply. So there was no requirement for standard contractual clauses. So they cited the recitals, the SEC recitals, and previous public statements by the Commission to support this view. But this argument was rejected by the Dutch Supervisory Authority. And they found that that SCCs and other appropriate safeguards are required even for organisations subject to Article 3.2 of the GDPR. And I suppose as a result of this, then the Uber and the Meta decision, the Commission is proposing the adoption of a new set of standard contractual clauses, which will apply to data importers located outside of the EEA, but which are already subject to GDPR. So where they're established in the EU or offer goods and services in the EU. And the public consultation process for the new SECs is yet to be commenced. And very importantly, as is the case in many of these fines, Uber is appealing the decision at the moment.
By listening to you, I was thinking about another point which is key, which is the role of the authorities in some cases. We all know that the DPC often acts as the lead supervisory authority within the EU, and that's one of the key reasons for us to be particularly happy to have experts from Ireland speaking with us about those cases, because the Irish DPC is often in the lead. And that's been, quite active, as we all know, in the recent years. Also based on what you were saying, and also based on the fact that the DPC has this role also to take decisions that will affect the others, because of course there is always a domino effect when you take certain decisions, and they have a very important role in this regard. Do you have any comments in relation to this, and based on what we discussed so far?
Yeah, I mean, I suppose absolutely. The DPC, unlike a lot of other supervisory authorities in data protection across the EU, when the DPC started off in 2018, it had never had a power to impose a fine. It always had to go to court to prosecute cases. So it was learning, on the job when these fines came in. So it took quite a while for it to kind of get up and running. But it really has now started to set a number of very high profile cases and high fines. I think last year, the fines imposed by the DPC were around 650 million euros. And I suppose for the most part, they related to large tech companies, but they're also fining smaller companies in areas such as breach of privacy on email accounts, lack of technical and organizational measures, unsolicited marketing emails, and disproportionate use of CCTV. But I suppose if you look at the trend, they also have low-hanging fruit, such as failure to notify on time. That's an easy winner. And then obviously the Article 32 security measure, adequate appropriate security measures, that seems to come up a lot. So there's kind of a theme, but they are active, and they're active, and Irish businesses have sat up and kind of taken note as well, because they're focused in on local businesses as well. So I suppose the TikTok fine, though, really is indicative of a greater focus on the area of transfers outside the EEA, and DPC's stricter oversight and accountability for non-compliance in this area. And they themselves have kind of indicated that they think, and I don't know if I necessarily agree with this, but they think that there's a lot more certainty in the law since GDPR, which allows them to make decisions to impose fines on novel areas of the law. Now that's, so that's where they're straying. Hence a lot of appeals, which means that you're going to have courts making decisions as well on these decisions. And I suppose in the DPC's view, they obviously are saying that this fine is a welcome development and a trend that they're hoping to continue in terms of enforcement. So I suppose it's not the end of the story; it's just the beginning, really, and we'll see where we go from here.
Yes, absolutely, and thanks a lot for this, because I mean there is a lot to monitor, I would say, in the future. But so far, I would like to thank you very much, both, so Zelda and Sean, for being with us today. We are running out of our time, so unfortunately I have to close this session. But again, thank also to all our listeners for being with us, and we very much look forward to meeting you all for the next Privacy Espresso. So Zelda, Sean, thanks, and see you very soon again.